Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
You blogged about it a lot. You talk about it. This next suit is so interesting. I hope
so
not
many
just
levels,
the attorney.
so many
Oh my
levels.
God.
We could talk about this. So
Yeah, and I think about Scott Air Packs, the lawsuits and MSA and all that. But okay, so here's the facts are simple. I'm going to make the facts simple. If you want to expand them, expand them. But here we have a widow of a deceased, obviously deceased firefighter. The firefighter is a Maryland firefighter. He died in a house fire as a result of gas piping that was allegedly known to be defective, but was unquestionably the cause of the fire. And there's this would, has resulted in a products liability suit against the manufacturer. That's the easy part of the facts. The problem is in Maryland, you have the firefighters rule, and we'll explain that rule now. But in Maryland, you have the firefighters rule. The manufacturer of that allegedly or defective piping, all right, is housed in Pennsylvania. So everybody knows this is first year law school, and you spend a lot of You've spent a lot of time in law school on choice of forums. Do you sue in Pennsylvania? Do you sue in Maryland? And all of these choices to sue are allowed, right? They could sue where the manufacturer is, or they can sue where the product was used. Both of those give what's called personal jurisdiction to the plaintiff, right? The problem here is Maryland has the firefighters rule, which I'll explain now, and Pennsylvania doesn't. So they sue, the widow and their attorney very smartly choose to sue in Pennsylvania. Correct me if I get any of these facts wrong.
You got it right.
Okay, and in Maryland, so here's what the firefighters rule is. New York doesn't have it. A lot of states are getting rid of it. It's normally created by courts. It's a common law rule. Sometimes it's in statute, meaning it's in law. It's not court made, it's in law. But the firefighters rule says if a firefighter is injured on the job, that the firefighter cannot recover against whoever or whatever caused the injury because there's a heightened risk of injury expected in firefighting, and that's the choice you make. So it's weird. It's called the firefighters rule, but it applies to police, fire, municipal EMS, et cetera. And it prohibits the firefighter from suing anybody. So normally this comes up and I've had one of these. We won a good amount of money for somebody in a well-known case now in New York where a firefighter was directing traffic and a guy runs him over as he's directing traffic. And New York State's abolition of the firefighters rule, like many other states who have done this, say, listen, the firefighter's allowed to sue, and you can't even claim that the firefighter or the fire department was any way negligent, that anything they did wrong can't even be introduced against them. So the states, I make this point because the states that have abolished the firefighters rule or the prohibition of the firefighter from suing, the states have done so, a lot of them have, like New York, have gone the extra step in saying, and you, the individual who caused the injury, can't even try to get what's called comparative or contributory negligence from the firefighter or the fire department saying they did something wrong. So what's happened here? Maryland, right, does have the firefighter rule. Pennsylvania doesn't. You could sue the manufacturer in Pennsylvania, and if you could sue them there, that's the question of this ruling, which now we'll get into. If you can sue them there, then there's no prohibition to suing. So the court says, listen, and this is under a well-known federal test that which state has the I'm making this, wording this differently, but which state has the prevailing interest in having this case heard. And the court says, it's pretty equal, frankly, except that and they say, but what tips the scales in favor of using Maryland law and not Pennsylvania law, right? You can still sue in Pennsylvania, but the question is called choice of law, choice of forum. What law are we going to apply? Even though we're in Pennsylvania, should we apply Maryland law and prohibit the suit, or Pennsylvania law and allow the suit? And they kind of get in the middle, right? They apply Maryland law, saying Maryland is where the injury was, Maryland where the death was, Maryland is where the house was, where this allegedly defective product was sold. and they say, so we are going to use Maryland's under the choice of form. We're going to use, and choice of law. We're going to use Maryland's law, and so they can't. They might not be able to sue. Ultimately, though, doesn't this result in settlement?
Yeah, it does. And what the court didn't dismiss the suit. Like the company that made the pipe wanted the case dismissed. And the court
Right.
said, not so fast. Okay. We agree with you that Maryland law is going to apply. So the fireman's rule is going to apply to this lawsuit. However, Maryland law allows for several exceptions to the fireman's rule. And one of the exceptions, right, one of the exceptions is where there's an allegation that the manufacturer, in this case, or the defendant, it committed willful or wanton misconduct. And there's a number of exceptions. And you know, every state that has a firefighter's rule, fireman's rule, or however it's characterized, has different exceptions. One is that if the person who caused the fire or caused whatever it was aware of a hidden danger, they have an obligation to inform the fire department. Some have an exception for gross negligence or recklessness or willful and wanton misconduct or other things. So what the court said in this case was that the case can proceed not along the negligence route, but along the grounds that the manufacturer engaged in willful and wanton misconduct because they were aware of a dangerous defect in their piping and didn't do anything about it. They didn't alert people. They didn't notify people. They didn't notify fire departments that you have to be aware of this. And what precipitated this pipe breaking happened to be a lightning strike. There was some sort of lightning strike that led to the pipe perforating. And there's somewhere around 75 other examples of where this has happened and led to a fire that should have put the manufacturer on notice that this was a problem. And the manufacturer apparently is accused of making an economic decision not to notify people, to try to keep it quiet. So that's a sort of.
You got to imagine. Or you got to imagine large firms are lining up, and I'll tell you who I was expecting to be leading, or am expecting to be leading charge, are the insurance companies, right? These homeowners insurance companies saying we're going to sue to force them to remove and replace the known defective product.
Sure. And
I think
that may be coming. Yeah.
Oh my God! I mean, if you're one of these firms, and just so you know, I mean, this is not going to be a single, a one or two small person firm. These are incredibly expensive. This is Aaron Brockovich, right? I mean, this is exactly Aaron Brockovich going up against these companies, these large companies who make these products. I mean, is very expensive and very difficult. They settle. I'm not surprised at that because they don't want a verdict against them declaring this product to be defective.
Right.
And they certainly knowingly defective, right? And I'm surprised they got this far because in the discovery process, I should ask, has this reached discovery? Did this get past?
Yeah, I think so. I think they simultaneously, as I understand it, they simultaneously started discovery, and that was they started discovery and they started mediation. So they kind of did both of those. But this is a good example of sort of how a case progresses, because you have in this case the plaintiffs, the widow and the dependent children of the deceased firefighter filed the lawsuit. The first thing that the defendant tries to do is get the case dismissed. And if they can get the case dismissed, the case is over. But they weren't successful in getting the case dismissed. So then once the dust settled on that motion to dismiss and the court said, no, we're going to let it go forward on this willful and wanton misconduct angle, that's when I think they got serious about the negotiations. And I think I know approximately what the settlement was. There's some ways the decision has the attorney's fees in there, and the attorney's fees are roughly somewhere around 33% of the total settlement. So they didn't disclose the total settlement, but I think you can sort of reverse engineer the amount. But they got a pretty decent settlement. Certainly not what you should get in a case like this, but they got something, and didn't take them as long as it could have. It wasn't like a 7 or 8 year battle here to get to the point where they got a settlement.
Well, you got to imagine it's because the manufacturer does not want anybody, and I apologize for noise in the background to our listeners. The manufacturer does not want anybody to get a hold of these, secret engineering reports. I'm making that up, but this is
right.
Aaron Brockovich, right? But this is true with products liability. And, my good friend of mine, and a partner in another business, did a lot of products liability suits. And when you get a hold of that one engineer who's so upset that he kept this memo that's been destroyed by everybody else, saying this is known defective product, you got to remove this. Once you get a hold of that, this company's bankrupt. But you're going to see more of this. If I'm the homeowners insurance companies, I am suing to get this removed and replaced out of homes. And if you're a homeowner, right, which inevitably will join the insurance companies in this, this is just the first of many lawsuits as against this company. This company's not having a good day. But you know what? They caused the injury. They caused the death, and no firefighter should die because of a defective product in the house.